Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV140500, Pond First versus City of Phoenix et al. Council, we are recording today's proceedings, so when you step to the podium, please identify yourself and your client. Each side will have 20 minutes for argument, and Mr. Baker, as appellant's counsel, you're responsible for watching the clock on the podium and saving any time for rebuttal that you might desire. And the appellees are responsible for dividing your 20 minutes between yourselves however you see fit. We have read the briefs and we've conferenced the case prior to argument. So with those preliminaries out of the way, Mr. Baker, you may proceed.
Good morning, Judge Downey, Judge Orozco, Judge Portley. My name is Thomas Baker. I represent the appellate Pond First. The briefs in this case are fairly extensive. I think we've all said pretty much everything we want to say. There's really two issues involved. My client believes that the City of Phoenix Board of Adjustment has been improperly granting variances based upon criteria not set forth in the state statute or the city ordinance. And the two issues presented in the court is whether the variance at issue is a use or area variance. The parties are in agreement that in Arizona, a use variance cannot be granted. I don't think you hear anyone arguing the contrary to that. So the question is it's a use or a variance. If it's a use variance, then discussion's over. The variance was unlawful. If it is an area variance, then we move into whether sufficient evidence was presented for the board to have jurisdiction and then make the findings to issue an area variance to open a pawn shop within 500 feet of a residential district. And I know you're aware the state statute is ARS 9 462.06 G2 and H1. The city ordinance is section 307A9 and A10. And under the city zone guidelines, well, let me begin with the use versus area argument.
Well, the only way for a use variance would be the city council has to rezone the parcel, right? It couldn't be the board.
Or eliminate the 500-foot.
But then, isn't that really the difference between a use versus a area?
Well, if they eliminated the 500-foot distance separation, then a pawn shop could open in a C2 or C3. And the question is, well, is that 500-foot separation an area variance, which is traditionally defined as something within the four borders of the property, height restrictions, setback, occupancy levels, height, things like that.
But isn't this really analogous to a setback requirement? It's a dimensional restriction.
Well, it's not within the four corners. All of the area variances seem to be within the property lines. Even setbacks, side yards, front yards, are within the yard to the property line. They don't go to the next adjacent property line, or in this case, residential district. So what we have is an ordinance that's written in a C2 or C3. You can open a pawn shop. However, you can only do so in a location that's at least 500 feet from where the exterior corner of the building of the pawn shop is at least 500 feet from the nearest residential district. And I think there's no good Arizona law on this issue, and it's an issue that needs to be decided because it's in a number of ordinances in a number of cities. And I think the starting line to ask is, may a pawn shop operate at that location without a variance? If the answer is yes, but it wants to change something, setbacks, size, height, what have you, it's an area variance.
Well, isn't that what this is? I mean, the pawn shop can be there. It's under C2 zoning, in the zoning of a C2, even though this is C3, but C3 allows C2 properties. And so isn't the answer to that yes?
No,
That it can be.
they can't be without a variance because they're within 500 feet of the nearest residential district. So you start with,
Well, what's the difference between that and a setback? Because let's say that they wanted a variance for the setback. Couldn't, the answer would be no, because the setback.
no, because they could operate the business. It might be a smaller building than they want, but the use would be permitted. They might want to change the setback to expand the size of the building, increase parking, build a second level, those type of things. So the use would be permitted, and then the dimensions within the four corners of the property, they would be requesting a variance to change those.
I guess I don't see the difference between it seems to me that, that in this C3 area, a pawn shop can exist.
Not without a
And-
variance,
Well, it can exist, but it needs a variance.
correct.
And
So-
doesn't, and wouldn't if the pawn shop was instead asking for a setback,
Mhm.
it could exist, but it would need a variance for the setback.
It couldn't exist without first getting a variance for the 500 feet. In other words, if you take the property as is, any property, can the use, the intended use of the property be used without a variance? If it can be used without a variance, then whatever variance they're asking for to change the internal dimensions is an area variance. If it can't be used for the intended purpose without a variance, then it's a use variance.
I guess we can agree to disagree. I just don't see the difference between a 500-foot requirement and a setback, because both of them allow the pawn shop there. But with your, in this case, you're saying you can't have it without the variance, and I don't see how the setback is any different. And I guess we could just agree to disagree.
Maybe it's terminology. What I'm saying is that if you can occupy the property
And you can in this case.
and use it for the intended purpose, which you can't,
Well, you couldn't if you didn't have the setback either.
well, a setback would be side dimension, front, rear,
I
height.
agree, but it's just, let's just call it a problem with the setback.
Okay.
You can't, if you don't have the proper setback, you can't use it.
And along those lines, you've cited a number of cases, but I don't read any authority, I haven't located any authority that stands for the proposition that it has to be this intra-property dimension. What stands for that proposition?
Well, all the cases dealing with area variances have been with issues within the four corners of the property. The setbacks, the heights, the different dimensions for construction, not the use of the property.
And so you intuit from that the notion that it has to be intra-property, even though none of the cases come out and say that, they just all happen to involve intra-property dimension issues?
Yeah, there's a couple of cases we cited in our opening brief, setting forth the common factors that are subject to an area variance.
I don't want you to run out of time, and I think we're equally interested in the second issue. And so let's assume for the sake of argument that we think it's an area variance.
Okay.
Tell us, or tell me, why the condemnation proceedings wouldn't satisfy the criteria of the zoning ordinance.
Because they occurred approximately 42 years ago. The property owner was compensated at the time.
Well, but
It's been
let me
constantly-
let me focus it more specifically. One, there are special circumstances applying to the land, building, or use that don't apply to other properties in the district. Why wouldn't the condemnation proceedings qualify under that provision?
Well, we did supply the affidavit from our registered land surveyor who went through the properties, and 42 of the 44 properties on the south side of McDowell all had condemnation
Okay,
proceedings.
but let's narrow it to the language of the ordinance. It's properties in the district, and we've only got, as I understand, 13 parcels in this district. Is that accurate?
That I'm not sure of.
Well, it's important because the ordinance is all about that. It's special circumstances applying to the land that do not apply to other properties in the district. So we're only looking in the district as I read that.
In the C3 district? I believe all south of McDowell is C3.
Okay, but so isn't the relevant inquiry for us whether this parcel is adversely affected, I'm speaking loosely, more so than other properties in the C3 district?
Well, the setbacks have been moved in because of the widening of McDowell and 32nd Street. Number of businesses affected. But what the real problem is, even accepting the condemnation proceedings and limiting the property to 25 parking spaces, which is quite a few, how does it make, where's the nexus between them coming in and saying, look, this business can only be operated, we can only enjoy our property rights by operating a business that's prohibited under the ordinance without a variance, as opposed to any other 514 uses permitted in a C3. And this building has been occupied and operating as a business continuously to this point. They can't come in and say, look, there's something so unique about a pawn shop that only the pawn shop can operate on this property now. This property is no good for any other
But
of
you're
the
focusing only on
514.
use, and the ordinance is there are special circumstances applying to the land, building, or use. So we're not only looking at the use, we're also looking at this particular parcel and whether it was more affected in an adverse way than other properties in the district. And it seems the condemnation proceedings, if the record supports a finding that this parcel was more adversely affected, would qualify. I mean, you're focusing on use, which I understand, but that's only one thing. It can also be the land or the building is differently situated.
Well, I think just because a property is differently situated doesn't mean you're entitled to a variance, because even the city's own ordinance says, to that end, the authorization of a variance is necessary in order for the owner or applicant to enjoy reasonable and substantial property rights. In other words, without the granting of a variance, the property cannot be reasonably used. There is no cause for a variance if the property can be used, even if it is in a manner other than that desired by the owner or applicant.
And what are you citing from right now?
The city's own ordinance, and that's on page 9 of the reply appellant's answering brief. City's own publication.
Is that your reply brief or the appellee's response brief?
It is in my reply brief, Your Honor.
You have two reply briefs.
Yes,
so
to the City of Phoenix.
City of Phoenix, okay.
Appellant's reply brief to appellee City of Phoenix.
Okay.
Page 9, number 3. And right above it, it says the condition is considered a property hardship, and it must be a condition relating to the property that's so unique it cannot be replicated on any other similarly situated zoned land in the city. This property can be used for, again, you go down the list of 514 lawful businesses. This was a bar with an SOB overlay. If it can be operated,
Sexually
sexual-oriented business, if it can be operated as that for 40, 50 continuous years, it can be operated as a neighborhood bar without the SOB. It can be operated as anything, a barbershop, a bookstore, secondhand dealers. The only difference between a secondhand dealer and a pawn shop is the pawn shop makes collateralized loans. Secondhand dealer buys, sells, trades, and consigns. This property, if it can operate as a pawn shop, can operate as a secondhand dealer, which requires no variance. There's nothing unique about this parcel that says only a pawn shop would give the property owner.
Why shouldn't the condemnation from the 70s be considered a special circumstance in the 21st century?
because it has proven itself through continuous occupancy to be suitably situated for businesses other than those prohibited by the ordinance without a variance.
But is that argument asking us to reweigh the evidence, which you know we don't do? We give great deference to, this isn't an agency, but the agency-type administrative appeal procedures and laws substantially apply. Aren't we supposed to give great deference to the board's assessment of those kinds of issues?
Well, you are, but you're also allowed to independently reweigh it to find the jurisdictional basis for the Board of
Jurisdictional, I
Adjustment to
agree
act.
with you.
So here we have, and we cited the Mueller case, the state Supreme Court, that says the Board of Adjustment can't simply mouth the jurisdictional requirements of the board to render a decision. And that's essentially what they did. And even the property owner at the time, their lawyer came in and said, look, this is all about rent. The pawn shop will agree to pay more rent. We're tired of dealing with the SOB issues. So we want to rent it to a pawn shop. They'll pay more. And as we know through the Arizona cases, economic reasons are not a criteria for granting a variance.
But wasn't there also evidence in the record that the neighborhood supported this and felt that it was better for the neighborhood than the SOB business?
Sure, I mean, take your pick. SOB or pawn shop, that was what they signed off on.
Well,
You
I'm
call that
just saying, we have to
support?
find that there's some support in the record, so arguably there's some support in the record for that distinction, whether we would have made the same distinction or not.
But we know from the prior, 3 months earlier, there was this same Board of Adjustment.
Yeah, but we can't consider other cases and what they did there. I mean,
Well,
that's.
sure, it
that's-
shows that they're arbitrarily issuing these variances.
Not unless we have the entire record from that other case. I mean, I'm not even sure it would be an apt comparison, but we can't just say, oh, well, they treated somebody else who may look the same on paper from a distance without the entire record differently. I mean, I didn't think that's really was an argument that would help you.
Well, they made the finding that the pawn shop would be detrimental to the neighborhood, 100 yards away. And then in this one, they say it won't be. There's no distinction between the two. Pawn shop's a pawn shop. They're 100 yards apart.
Really, ownership can be a factor. We can also, as Judge Orozco said, agree to disagree on that one.
Because even if it's this pawn shop, it's another one next year when they sell.
Some of them are really nice.
Some of them are, some of them aren't. I'm not arguing that pawn shops are bad, but I'm saying that the owners come and go. And with that, I'll have to reserve.
Okay, thank you.
Thank you, Judge.
Your Honors, Paul Lee here on behalf of City of Phoenix and City of Phoenix Board of Adjustment, and I would like to reserve about 10 minutes to the real party interest attorney. I think, obviously, we're both prepared to answer both issues presented to the court, but for ease of division of labor, I focus on the first issue, which is use versus area variance, and Mr. Bell will focus his presentation on whether there's any evidence supporting the decision. But again, we're happy to answer any questions you may have. Your Honor, I think first of all, I want to piggyback on something Judge Orozco talked about, which is, isn't this essentially a setback like any other? And obviously, C agree with that position. This is, imagine, let's put in a more real life situation where I own a house, and for the most part, there's always a separation on your side yard between your property and your neighbor's property. And now where I was on residential, you can obviously use a house for residential use. But if you come into the city and say, hey, I want to encroach that side yard variance and build closer to my neighbor, it doesn't mean that your use is prohibited. The city will tell you, well, you either have to change your design or you have to get a variance. This is an identical situation here. The pawn shop comes into the city in a C3 area appropriately zoned for pawn shop use. So city go through different separation requirements, say you have to have certain distance setback from the street and from your neighboring property. The 500-yard separation to a residential zone property is no different than your own property, your side yard separation to your neighbor's property.
Mr. Baker argues that the distinction making it an area variance is something that occurs within the four corners of the property and that the case law so far has focused only on those issues. Do you agree that the cases have focused on intra-property four corners types issues to date?
Thank you, Your Honor. I respectfully disagree. I think if you read our brief, we cite a case in New York, I believe it's called Real Holding, and that's a variance, a distance separation between a for-profit health club and a residential zone property. We also cited an Ohio case, which I think it's called Faith Walk. That's a distance variance between a church and, again, with a residential zone property. So I think clearly we have cases from New York, I think also New Jersey and Ohio, supporting the proposition that a distance separation between two permitted uses is an area variance permitted to be granted by Board of Adjustment.
But in the New York case, they had a specific statute that defined both the use variance and area variance. It wasn't a common law matter that the court devised, but one where they were interpreting what a statute said.
Your Honor, you're absolutely correct, but I think, in essence, New York statute gives us some guidance. I'm certainly not saying that it's a controlling issue. And let's just disregard the New York case if you believe that, if you take the position that the case is really an interpretation of a set of statutes that's unique to New York. You used to have the New Jersey case about the for-profit health club and the residential zone property, and as well as the Ohio case, Faith Walk. That's between a church and a residential zone property. Those, I believe, are common law cases, making a distinction between the use variance and area variance. Your Honor, I think the second point I want to raise is that if you look at the statute, and this actually goes to a little bit Judge Porley's question about rezoning, the Board of Adjustment statute, which is Section 9-462-06, give broad discretions to Board of Adjustment on making variances to zoning standards and requirements. And obviously, there's the four-factor test that's prescribed by the statute. But the only real limitation in the statute is that the board does not have the authority to cannot make any change in the use permitted in a zoning district. And the reason is pretty clear. The only way you can add or subtract use from a particular zone, from your property, is to go through City Council, whether it's a rezoning process or whether it's a change or entire zoning ordinance. In this case, the real party interest did not come to the city asking for it and use that's not otherwise permitting C3. Any C3 property can operate a pawn shop. That's permitted. The council made that legislative determination. There are additional requirements that are imposed by the council that are not related to use directly. It's about the location, the size, and that's no different than any other type of dimensional requirement adopted by the council. And the Board of Adjustment has the authority to make to grant variance relating to that. Your Honor, I think as appellant's attorney stated, I think the case is really well briefed, and unless you have any questions, I'd like to give the remaining time to
I have a question that may be more appropriate for
Sure.
Mr. Velvet. Since you're from the city of Phoenix, you may know the answer readily.
Absolutely.
When we talk with him, we need to focus on the in the district language from the zoning ordinance.
Mm-hmm.
Are there only 13 parcels in this district?
there are only 13, just to be clear, you asking whether are there only 13 C3 parcel in the district?
Well, I'm trying to figure out the district, because the district is important when we talk under section 307A9. There are special circumstances applying to the land, building, or use that don't apply to other properties in the district.
Right.
So I'm trying to figure out what is the district that we're concerned with here.
Your Honor, I think the district you're concerned with is C3 property. And I don't know I can't tell you how many C3 properties we have within the area or within the city of Phoenix at this point.
Well, wait, you're saying in the district means the entire city of Phoenix? You're saying it applies to every C3 property?
No, well, I think the uniqueness, it applies to a similarly situated property.
In the district,
In the
though.
district, correct.
So what is the district here?
Your Honor,
In this case.
I think in this case, it's a C3 property. That's a district.
The entire city of Phoenix, every C3 property is the district?
Well, all the C3 properties are supposed to grant the same entitlement, which
I
means.
get that,
right.
but that just can't be. That would require us to look at every C3 property in the entire city of Phoenix. In the district, I understood to be the 13 parcels that are sort of the triangular shape
Right.
at issue here.
Your Honor, I think certainly City of Phoenix is in a unique position. It's a pretty big city. I think what you're looking for in terms of similar situated properties, that it's not that it's zone C3, but they have similar characteristic and in the adjacent neighborhood. Because a C3.
That's not what it says. It says in the district. So, I mean, we really need to know that to know when we talk with Mr. Bell
Mr. Bell, yeah.
about whether the proof was sufficient to establish disparate treatment as to this property compared to other properties, quote, in the district.
Right. Your Honor, I think again, the district, the point of having a district is that each district, again, I'm sure, maybe I said this before, it means that all the districts supposed to have the same entitlement. And, but that doesn't mean each parcel within the same district have similar characteristics that pose a hardship. There are plenty C3 that's wider, that's located in an area that's easily accessible, that can be used for many other purposes. And I think your focus is that on this particular C3, whether there's any special circumstances that's unique to it, that's different from other C3 property.
In the entire city of Phoenix.
Your Honor, I wouldn't say the entire city of Phoenix. What I would say is that there are many factors to be considered. I mean, you raised condemnation as the issue, whether.
I mean, really, but it's such a threshold issue. So
Yes.
I guess and I don't want you to deprive Mr. Bell of all of his
Yeah.
time, but our focus has to be on the proof comparing this property to other properties in the district. So we kind of need
Yeah.
to know what the district is, but maybe
Your
Mr. Bell will tell us.
Your Honor, yeah, I think I'll defer to
All
Mr.
right.
Bell. I think
Lucky
he's
him.
ready to pounce on that question.
And he looks ready to pounce, sure.
Thank you,
Okay,
Your Honor.
Thank you.
Good morning. I'm Jim Bell. I represent the real party in interest, William Jacomek. In answer to your most recent inquiry, I'm not sure how many parcels there are in the district that this particular property is located in. I would think the statute or the ordinance refers to the district in which the particular property is located, not other C3 districts around the city.
I would tend to agree with you on that. And I'm trying to remember the source of the record, but there's a triangular shaped grouping of properties where, and this is the corner, I believe, down here of the triangular shape. I was under the impression that was the district we were talking about. But
As I recall it, it went McDowell, 32nd Street, and the Grand Canal, and that was the district. Is that?
I believe that's correct, but I can't stand here and tell you absolutely I know that.
But you agree that we have to compare how your client's property exists compared to other properties in that same district, not compared to other C3 throughout the entire city.
I agree that the Board of Adjustment had to do that.
Yes.
I don't think that this court has to do
No,
that.
but they had to
given-
do that. So I guess where in the record is the best evidence that you're focusing on the condemnation proceedings in large part to show that this property was disadvantaged by circumstances beyond your client's causing?
Right, that happened in 1973, and my client presented evidence that the Board of Adjustment considered from Dorito Realtors. They did a survey, and this is cited in our brief, of the 12 surrounding intersections in this C3 zone, and found.
See, are those within the district?
Again, I would have to go back and look at the record. I had not, to be honest, I had not focused on that before.
You see
before
why
I
we're
heard you.
asking, because that's the language of the ordinance.
I understand what you're asking, yes. I do know that evidence was presented, and I think, but I cannot sit here or stand here and tell you for sure, without going back to the record to see. But my understanding is that the intersections that Dorito surveyed were 12 other nearby intersections that would have been in the same district where this property was located, and found that none of them were as small as this property. They also had an architect testify that there were only 9 to 12 parking spaces available at this facility because of the very limited size of the lot. And there was testimony presented. Let me make sure I'm right about this.
But assuming those survey properties are within the district, then your position is that provided sufficient evidence for the board to determine that there were special circumstances applying to your client's land that didn't apply to others, and that those special circumstances predated your client, and so he didn't create the conditions.
Right. Those conditions went back to 1973. As a result of that, there were no setbacks between the building and the sidewalk. There were not very many parking spaces. Our testimony was 9 to 12 parking spaces. And testimony also was that a pawn shop was really the only business that was viable there, because it has a very limited number of customers, that being 25 or fewer per day, and very few employees. It's different than other retail type businesses or restaurants which require far more parking that didn't exist here.
But what about Mr. Baker's argument that, well, after the condemnation proceedings, the sexually oriented business operated successfully there for a number of years, so it's not accurate to say a pawn shop was really the only viable use?
Well, it's the only viable conforming use, and another special circumstance that the board took into consideration was that by allowing the variance to the pawn shop here, it was extinguishing a prior non-conforming use to the benefit of the community, and allowed for the sexually oriented business to no longer exist there. And that is a benefit to the community. We introduced evidence at the hearing, 300 letters from nearby residents and business owners supporting this move. We presented letters from every resident who lived within 500 feet of the structure saying that they approved of this. So I think it's very clear that that was a benefit to the community, that the community appreciated, and that requirement for issuing this variance was well substantiated. And I would submit that all of the requirements were substantiated in a way that, given the standard of review that's applicable here, that being very deferential to what the Zoning Adjustment Board did, looking at the evidence in a light most favorable to upholding its decision, and not reweighing the evidence, not substituting the court's judgment if it thinks that the decision was ultimately wrong that the Board of Adjustment made, but to accept in the most favorable light the evidence it reviewed and affirm its decision, unless that decision was based upon no credible evidence and was purely arbitrary and capricious. And that is a standard that I do not believe Pawn First can establish in this case, because there was a lot of evidence presented to support the issuance of this variance. And Mr. Baker has talked about some of the evidence, like he mentioned 25 parking spaces. Well, there may have been contradictory evidence in front of the board, but that doesn't mean that the board's decision can be reversed. Much of the brief that Mr. Baker has submitted, the briefs, talk about different matters of evidence that were supposedly presented to the board that would have been negative in regard to whether the variance should be issued. But that's not the issue here. The question isn't what contrary evidence was there. The question is what evidence in support of the board's action was there. And if there is any credible evidence to support it on these points, then its decision has to be affirmed today and not redetermined by the court.
How long should the condemnation for that corner of 32nd and McDowell be considered a special circumstance? If not for, your client, 10 more years, 20 more years?
I think it remains indefinitely a special circumstance. It's a burden on the property, not any particular owner of the property. It's a burden on the property itself. And the configuration of the property is not subject to change. So the restrictions and the burdens that were placed on it by the condemnation will go on indefinitely.
But was there any evidence in the record to show that more property was taken from this corner than say other properties in the district, or was there anything?
The evidence was that this property ended up smaller than other corner properties as a result of the condemnation. This lot may have started out smaller than some of them, and then as a result, the reduction in size was a more dramatic problem for this lot than another one. And that would be a special circumstance as I see it. It's how the property ended up in comparison to other similarly situated and zoned properties in the area that makes it a special property and in need of this variance in order to allow a business to operate there effectively.
And I think we come back to the question of what's a district, and I tend to agree that if the board could, I should say, consider the properties set forth in your client's survey report, there was at least evidence to support the decision. But if district is defined more narrowly as sort of that triangular area that Judge Orozco talked about, did anything focus on those other properties? All of those were affected by the condemnation, but did anybody try to say that your client's property was more affected by those others in that triangular shape?
Your Honor, I cannot honestly tell you what properties the survey looked at. It may be that all of the properties there were within the area you're speaking of. I don't know. This was not anything that any of the parties or the Superior Court focused on. If you'd like some supplemental, information on that, I'll be happy to try to provide that, but I just don't know as I stand here today. I see my time's down to 5 seconds, so thank you very much.
Thank you. Mr. Baker, rebuttal?
Thank you, Your Honor. Just to address this in the district that you're very concerned with. The zoning districts are defined by city ordinance. The residential's R1, R2, R3. The commercials, C1, C2, C3. They're citywide.
Are those districts or classifications?
They're zoning districts.
Well, they're not, we've been looking for the definition of a zoning district and can't find it. So you would agree then with Mr. Lee that the relevant comparison is every C3 property in the city of Phoenix?
I'm saying that under the ordinance where it says the properties, similar properties in the same zoning district that cannot be replicated in any other similarly zoned land in the city.
But those are two different things, zoning district versus zoned land in the city. That's kind of the rub here, it seems.
I think you'll find zoning district defined under the ordinance, if not by state law. And additionally, again, if we go back to the city's own ordinance and their interpretation is, in other words, without granting a variance, the property cannot be reasonably used. There's no cause for a variance if the property can be used, even if it's in a manner other than that desired by the owner or applicant. And clearly, this property can be used for something, one of the 514 other things that's lawfully permitted in a C3 zoning district, other than one of the very few businesses that require a variance to operate there. Just hundreds of businesses can operate there. The reason the property owner stated through his attorney at the Board of Adjustment, it was economics. The pawn shop would pay more rent, and they were tired of dealing with the SOB crowd. That's why they wanted to have the variance approved, strictly dollars and cents. Thank you, judges.
Thank you. Thank you all for your presentations. It's an interesting case. We will take this matter under advisement and issue a ruling in due course. And at this time, the court stands adjourned. Thank you.